First and foremost, Libertas Wealth Management Group is a fee-only, true fiduciary financial planning and investment management firm. My name is Adam Koos. I am the president, portfolio manager, and senior financial advisor at Libertas, and I'm being joined by Kim Warwick, who is CFP and our lead financial advisor here at Libertas. But anyway, like I said, we're a financial planning, investment management, and business transition and exit planning firm. You can check us out at libertaswealth.com. You can also find us on YouTube, Instagram, TikTok, all the socials. You can find me personally on LinkedIn as well if you want to connect with me personally. And then last but not least, if you ever want a second opinion on your estate plan, tax plan, insurance plan, investment strategy, or retirement plan, second opinions are welcome. You can set up an intro call just by going to our website at libertaswealth.com, clicking on the little button that says "See if we're a good fit." And then that'll send an email to us, let us know that you have some interest in just having a quick, call it 20-minute phone call. We get to know you, you get to know us. We tell you how our process works with our clients, and then from there we either part as friends or we move forward with the process. Which again, there is no cost for that. So that's enough about us. Let me get into an introduction of Dan Barron. I'm really excited to introduce Dan because I've known Dan for so long. It's crazy to me that I've been doing this for a living for 23 years now, but I've known Dan for almost the same amount of time. And Dan has offices. He's an estate planning attorney, and he's got offices both in Columbus and Cleveland. In fact, multiple offices. And he's had a lot of success just doing what my dad always told me to do when I started my business, which was to pretend like everything you do is in tomorrow's front page and just let the rest take care of itself. So I'm really, really proud to work with Dan. I'm really proud we send our clients to him for estate planning needs because he's not only an expert in estate planning, so things like trusts, wills, powers of attorney, healthcare directives, testamentary trusts, and all those kinds of things, but he's also an expert in elder care law. And I don't want to throw any shade here, but in the elder care law world, in my humble opinion, it is extremely difficult to find really good, ethical, top-notch attorneys. And I am willing to put my 23-year reputation, easy for me to say, on the line here and say that Dan is one of those people. So Dan is the founder, or the founding member, I should say, of Barron Law, LLC. He focuses on estate planning, elder law, probate, and business succession planning. He helps clients plan for their legacy while protecting their assets through trusts and other estate planning tools. He's also a published author and founder of the annual publication Dollars and Cents. For the last 5 years, he has been nominated a Super Lawyer, Rising Star, an award given by his peers that only the top 2% of attorneys even receive. Most recently, this year in 2024, he was nominated Best Lawyer, One to Watch, a national recognition also given by peers. He volunteers regularly for the Boys and Girls Club, and in his free time, he enjoys four-wheeling trips around various parts of the country. He is truly a nomad. Dan, take it away.
All right. Well, thank you so much. Pretty sure my mother was the only one who nominated me for the Super Lawyers nomination. But thanks everyone for being here and for since we didn't know we were on camera. Just a little housekeeping. I was going to mention it anyway. If you have questions, by all means, I prefer that this is more interactive. So you could raise your hand in the chat, and we'll unmute you or what have you. And we're happy to answer those questions. So just let's see here. Is this working? There we go. Quick disclaimer. So yes, I am an attorney, and as Adam already mentioned, focusing on estate planning and what have you. But don't take this as attorney-client relationship. Yeah, you're going to learn a lot of things today. I'm going to teach you a lot of laws, but as my Bitmoji here, this is not legal advice. It's just for educational use only. So the most important thing that I want you to remember, and you'll probably want to write this down, and the most important thing is that I have the cutest dog in the world. So this is Bubba, and he's the mascot of our firm, and he's also the mascot of classes that I teach. I teach at several local community colleges. And the reason he's our mascot and the reason I even bring him up, number one, he is cute, but the reason is this. So here he's cute and cuddly. I got him. He was only 8 weeks old in this picture. And look at those paws, right? But as we all know, things change in life. And so here he is not so cuddly anymore, tearing up the couch. And just like with financial planning, Adam will tell you, same with estate planning. It's not a one plan fits all. And as you're in your 20s and 30s, your plan is going to be much different than it is when you're in your 40s, 50s, and 60s. And same with Bubba, my dog. When he's 8 weeks old, things change. When he's 2, 3, or so forth, um, you might have a child who is a straight A student, or you might have someone like Bubba who tears up the couch, and maybe we consider a trust for that child. Of course, health is a big thing with estate planning. And here, Bubba got stung by a bee. This is the last picture of him. And so, if there's any dog owners participating, 1 milligram per pound will knock out a bee sting. So he was 40 pounds here, and he enjoyed a Burger King burger with a couple Benadryl pills, and it knocked it out when he got stung by the bee. So, all right. So let's talk before we get into different types of planning. Let's talk about why we plan in the first place. So, probate, taxes, and long-term care are the three main reasons why. Why do we care in the first place? Probate court. Some of you may have gone through this, and if not, let me explain what probate court is and why you should avoid it. It is a court system, and it is a way to settle the estate of someone who has passed away. And the reason that you want to avoid your family having to go through probate court, number one, I mean, there is a judge, there is a courthouse, there are hearings, and so it's very time consuming. The minimum time of probate court is 6 months, and that's because creditors have 6 months to excuse me, make a claim through the court. The average time is roughly a year. And so depending on what county you're in, all in all, it takes about a year to facilitate the estate in probate court. So, this is an obvious question. Do you want to have your family spend a year through courts and hearings, or do you want something that's more seamless and where they don't have to deal with that? It's also expensive. So it's actually not in my best interest as an attorney to tell you to avoid probate court, because attorneys make a lot of money in probate. And one thing you will learn today in the next 45 minutes to an hour here is I will tell you exactly how to avoid probate court. There are 5 ways. Okay. But it's very expensive. So the average cost is roughly 5 to 10% of the value. So if you have a $500,000 worth of assets going through court, it's going to be $25,000 to $50,000 in court fees and attorney fees. And that's money that could have otherwise, went to your beneficiaries. Okay. It is also public. And so on any given day, it used to be that you could go down to the courthouse and get information. You don't even need to do that. You can just go on your computer and you'll get a list of any of the cases that are in probate, a list of all the assets, a copy of the will, a contact information for the executor. And so because it's public, this also can lead to scams. Okay. I'm executor for a number of clients, and I get phone calls every single day of people trying to buy properties or what have you. And so you want to avoid probate court as much as you can. Okay. Of course, everything does require court approval. You might think, well, I'm the executor, I can just go and sell a piece of real estate. Well, not necessarily. Everything has to go through the court. Okay. Taxes are another reason why we plan. And just a quick game, and you could type it in the chat, or so we have there's 4 people who have passed away, famous people. And our first person, she was a blonde bombshell, allegedly had relationships with one of the Kennedys. She had $819,000 in her estate, and she lost 55% through taxes. Who is she? Marilyn Monroe. Okay. Google this after we're done here. Her estate actually did not finish until 2002, even though she died in 1962. There were some complications with the validity of one of her wills and so forth. But nonetheless, she lost 55% in taxes. Not good planning. Our next person, everyone knows this, King of Rock and Roll from Graceland. Who is he? Elvis. And so Elvis had $10 million in his estate, but even worse than Marilyn, he lost 73% in taxes. Not good planning. Our next person, I'm going to give this one away. She was in the Donna Reed show. Donna Reed. So Donna Reed died 1986. Very similar assets to Marilyn. And she had $800,000 in her estate, but she only lost 4%. Something also interesting about Donna is that she had children from a prior marriage, and she got remarried. And, if you think about it, let's say that you have a will, or you get remarried and you name your spouse as joint account holder or beneficiary of those accounts, or even a retirement account, you name your spouse as beneficiary. Well, that is a way to avoid probate. Okay. Those are 3 of the 5 ways to avoid probate court. Upon passing, it'll just go to the spouse. But then there's nothing preventing that spouse from disinheriting your kids. And it may not even be intentional. It might be by accident. If you give everything to them and then they have kids from a prior marriage, well, you accidentally just disinherited your kids. You pass away, goes to your spouse. If you have kids from a prior marriage, that spouse's, their kids, that's who's going to inherit those assets. Unless you have a dual plan, or unless you did what Donna Reed did and you had a trust. So with her trust, she left everything to the trust. Instead of giving it to her spouse outright, it said that it would always care for his health, education, maintenance, and support. We call that HEMS. And then upon his passing, the balance would go to her kids. It's a very common scenario for people who are in a mixed marriage. Okay. But another reason why we plan, of course, is that we want to avoid taxes. She only lost 4%, so her planning was much better than Marilyn or Elvis Presley. Our last person will talk about taxes, and he was in Caddyshack. He was the judge, Mr. Ted Knight. $4 million in assets. He only lost 1% to taxes. He did really good, much better planning. So obviously, if I asked the question, would you rather lose 71% like Elvis or 1 like Ted? Well, of course, you want to do better and, plan better. So there's a comparison between everyone. And so finally, as we get into different types of planning, we want to protect our assets. And long-term care, costs of nursing homes, avoiding probate, protecting assets for our kids. There's a number of ways to do that, and we're going to get into it. So there's 3 different types of planning. And there's hybrids, of course, but generally speaking, we have basic planning, and that's what most of us are familiar with. We have revocable family trust planning. We're going to talk about that. And long-term care planning. And so depending on where you're at in life, and I'll say this twice, you may fall into 1, 2, or all 3 of these categories. And, I don't like to put an age on it, as I said, but let's say that you're in your 20s and you are not married. Well, then you probably should have a basic plan. I don't think you need a trust. But then when we get married and we have kids, now a trust should be considered. And depending on your circumstances, you might fit into that area, but you still need your basic plan as well. You still need your advanced directives and healthcare documents and financial power of attorney, whether you have a trust or not. And then as we get older, of course, we talk about long-term care planning as well. Okay. So here's our basic plan. As a reminder, if you have a question as we go along here, please hop in at any time. I intentionally have a college student here because if you're 19 years old and you're going to Ohio State and something happens to you, do your parents have the ability to make decisions for you or financially or otherwise? No. So everyone needs a basic plan. Okay. So there would be a will, HIPAA authorization that deals with privacy laws, guardianship if we have minor children, a living will. So that is not a DNR, but if two doctors determine if you're in a permanent, irreversible vegetative state, we're not putting the burden on the loved one to pull the plug, we're pulling it ourselves. Healthcare power of attorney and durable financial power of attorney. So let's dive in deeper to our basic plan here. Last will and testament. This is what most everyone is familiar with, and it's been ingrained in our minds for decades. Everyone should have a last will. But if you've done everything correctly, your will is never used. I'll say that again. If you've done everything correctly, your will is never used, because if we learned about 10 minutes ago, a will does not avoid probate court. A will does not avoid probate court. And about half the people listening, if I were to say, hey, raise your hand if you think a will avoids probate, about half the people would say, yeah, of course it does. Why else? Well, think about it. If you have, let's say you're single and you have a will and you name your kids as beneficiaries of your will and you pass away. And then they go to the bank and they say, mom passed, here's her will. Go ahead and deplete the account and put it to our name. The bank is going to say, we're not lawyers. We're not looking at the will. You have to go through court to tell us what to do. And in fact, only a court will actually interpret a will. Okay. So you should have a will, but it's a backup plan. Well, then how do we avoid probate court? Why do we have a will in the first place? Well, over here, a trust, and I'll get more into trusts in a minute here, but a trust avoids probate court and it supersedes your will. The will is not used. Joint and survivorship. So most common example is husband and wife. They own real estate together. If wife names her boyfriend in the will of who gets her assets, but she passes away, well, by virtue of the house, husband and wife being joint, it will automatically go to the surviving spouse, the husband. It doesn't matter what the will says. Okay, joint and survivorship supersedes your will. Transfer on death. Transfer on death and payable death, they mean the same thing, but one deals with bank accounts and one deals with title. So this might be one of the most useful pieces of information you'll get here is, and you don't need a lawyer for this, your car. Your cars have title to them. And if you name someone in your will as beneficiary, well, that person cannot go to the BMV and say, hey, put their car in my name. They will say you have to go to probate court. So how do you avoid that? Google this and just Google BMV TOD or BMV transfer on death. And what will pop up is a one-page form that you can download as a PDF. And you will name the beneficiary of your automobile. You take that form and you go to the BMV. You have to have it notarized. And they will issue a new title for $25. And whoever you've named, whether it's your spouse or your children, and they do not have to go through probate anymore. All they would have to do is provide a death certificate, and now your car does not go through probate. I would say in our office, we get a call 2 or 3 times a day of someone, mom or dad passed away, everything, is taken care of except for this car. And as the attorney, we're like, okay, well, it's going to be 6 months administration and at least $5,000 in legal fees. Well, sometimes the car's not even worth that, right? It's a total loss. And this is so simple that the BMV will charge you $25, but it's worth it to not put your family through 6 months to a year of having to go through probate court. Okay. So that's another way to avoid probate. Payable on debts. Those are bank accounts. It's the same thing. It's naming someone, but you don't have to go to the title bureau. You would go to your bank and you can name someone on the account. And then finally, beneficiary designation. So that's something that you would do with Adam for your retirement accounts. You name your spouse as primary, most likely, and then your children or what have you as the contingents. I caution you though, after this, don't run and just put beneficiaries on everything, because there are benefits to having a trust, and where instead of the assets going directly to the individual, they would go to a trust instead. For example, the most common is a minor child. You cannot name a 7-year-old as beneficiary of your retirement account. You have to have a trust, in that example. Nonetheless, even though a last will is part of our basic plan, that everyone should have one, I look at it as a safety net, because again, if you've done one of these 5 things on the right here, then your will is not used. Okay, it's not used, and that's good, because if we're relying on our will, we are going through probate court. Okay. Financial power of attorney as part of our basic plan. So another very common call we get, about 37% of people who call our office are calling about trying to get access to mom or dad's accounts. And they can't, because they never set up a financial power of attorney. Well, if your kids are calling us and trying to get power of attorney, and let's say that mom or dad are in a nursing home or something like that, well, it's too late, at that point. So we can't create that document unless the person who's creating it is competent enough to sign, right? But some things about our financial power of attorney, it is essentially, just giving someone the ability to make financial decisions. And is it current or springing? So you could set it up one of 2 ways. You can make it durable, current, meaning that if the person has it in their hand, that they can make a decision for you. Versus springing means that it does not spring into effect until you are incapacitated. So meaning that they have to get a doctor's to say, okay, this person cannot make decisions, so now their power of attorney is in effect. My personal recommendation, you want to pay close attention to how yours has been drafted, is that if you wholeheartedly implicitly trust the person who is going to make decisions for you, then don't make them go through red tape of having to get a doctor to say that you're incapacitated. Instead, make it easy for them and just make it be durable or current, that they can make decisions with the document in their hand. Okay. During the pandemic, we had a lot of calls to try and set these up, or that mom or dad already had a power of attorney. And a lot of times people set them up where you had to have 2 doctors determine that you were incapacitated. Well, the issue with that is, for example, a nursing home, they're only required to have 1 doctor on staff. So getting that second signature became very difficult. And in one instance, it took 6 months to get that second signature. So think about whether or not you want to put that burden on someone for your financial power of attorney. Limited or general? You could make the powers very limited, or you can make them very general. And again, if you wholeheartedly, implicitly trust your power of attorney, then I would make it very general and allowing them to act in any way that they can. New law, so there's something called hot powers. This is related to 2012. And hot powers are all with long-term care. So if you're in a nursing home, these hot powers might be giving them the ability to make gifts on your behalf, or the ability to create a trust, or to set up an annuity. And I won't get into too much detail. You're getting a 1 hour version of a 6 week class that I teach at the local community colleges. But 2 of those weeks are all about long-term care. And the bottom line is, it's use it or lose it. So if you don't give your power of attorney the ability to do these things for you, then you've lost them. And then if the long-term care scenario, potentially you could spend down through everything versus giving your power of attorney the ability to work with an attorney and save a portion of those assets. Okay. Um, Advanced directives, healthcare documents. And most of us are familiar with these, but maybe not familiar with how important they are. And these you don't necessarily need an attorney for, but I recommend it. You can go to the local hospital and they have them on file. Now, whether or not, those forms would be good in other states if you're on vacation, or with other hospitals, competing hospitals, that I don't know. But we have living will, healthcare power of attorney, and HIPAA. Okay. I'll start in the middle. Healthcare power of attorney, very, very important. Pretty easy to set up. And of course, this is someone who is making healthcare decisions for you. What procedures, medications, and if you're not able to make those decisions for yourself. So this is by default a springing document, unlike a financial power of attorney. Of course, if you name your spouse as your healthcare POA, they cannot unilaterally make the decision to remove your kidneys without your consent. So you must first be incapacitated before someone can make healthcare decisions for you. Living will. So it's not a DNR. Only a doctor issues a DNR, which, that is if you're in a terminal state. But a living will is more about if you're brain dead. So if you're in a permanent, irreversible vegetative state, then two doctors have determined this. You don't want to put the burden on a loved one to pull the plug. You're saying, I'm pulling the plug myself. Okay. HIPAA stands for Healthcare Insurance Portability Act, and it deals with privacy laws. So new law, everything's about HIPAA. And, of course, if someone wants to get information from a doctor or so forth, well, you have to give them HIPAA authorization to do that. Okay. Pretty easy to set up, but it's really important. So I'll give you a personal story and then a story from a client. So, we talk about HIPAA and healthcare. So I have a client, and I can hear the booze coming through the computer, but her son went to the University of Michigan. And 19, 20 years old, and he I don't know if you know this, but on your iPhones you can share your location. And so she checked in and saw that his location was at the hospital. So she calls her son, and he doesn't answer. She calls the roommate. He claims he doesn't have any information. So as a last resort, she calls the hospital and says, I know my son's there. His phone is there. What's going on? The hospital would not give her any information. So if you can imagine, without having this set up, and your son or daughter or loved one, that they're at the hospital, and you call to find out what's going on, and they will not give you any information. Pretty scary. And they didn't. They would not talk to her. Days later, she found out that he drank too much, and they had to pump his stomach. So figures, typical Michigan fan, right? So personal story, about 5 years ago, I swung a golf club just on a Thursday afternoon and herniated a disc in my back. Got rushed to the hospital. I was paralyzed from the waist down, and it was in the worst pain of my life also in my back. Never thought it would happen. Certainly didn't expect it. They had me on fentanyl, morphine, and Dilaudid all at the same time. I practiced what I preach. I had my advance directives in place. They contacted my healthcare power of attorney because I had it on file. No one carries them around in your pocket. So the next time you go to your doctor, they always ask you, do you have a healthcare POA? Get it uploaded. They had her information on file. They called her. She's a nurse. And, she saw things that I did not for two reasons. One, because she does have a medical background, but also because they had me on fentanyl, morphine, and Dilaudid all at the same time. So I wasn't feeling anything. And so I, had emergency surgery the next day. And had I not, I could have had permanent damage. So, we don't like to think about these things. It's a sensitive subject, but if we don't get these things in place, these are not things that you can set up as you're being wheeled into the hospital when you're not of sound mind. Okay. So, quiz time. Right. So these are a basic plan. Everyone should have them. And I'll go in reverse order, counterclockwise. First one doesn't avoid probate, but at least it tells the world who gets what and who's going to be the administrator of your estate. There's a will, the last will. The next one, someone to make financial decisions for you, durable or financial power of attorney. And someone to make healthcare decisions is our healthcare power of attorney. And again, our living will, not a DNR, but if two doctors determine you're in a permanent, irreversible vegetative state, that we want to make sure we're not putting that burden on someone else. Guardianship. We have minor children. Want to make sure that we're having our guardians named. And finally, HIPAA. We want to make sure that we give them access to our medical information. So again, don't have our college kid here pictured, but if you think of it that way, everyone needs it. It doesn't matter if you're 20 years old or 100 years old. You should have all of these in place. Let's talk about a trust. So a trust is our second method of planning. What is it, and when or why would we need it? Okay. Well, a trust is a lot like a will in that it tells the world who gets what. A will appoints someone in charge. So does a trust. A will, you can dictate specific bequests like jewelry or so forth. You can do same as a trust. A will you can amend as many times as you want. And you could also do the same with a trust. You can amend your trust, a revocable trust, as many times. But a big difference is that a will does not avoid probate and a trust does. Okay, so I always use this example. And so this is my treasure chest box. Okay. And so if this box is my trust, and actually let me see this, if I stop share and, never mind. We won't go that way. All right. Adam, can you still see my screen, Kim?
Yeah, we can see it.
Okay. I was trying to blow myself up. But that's all right. So treasure chest. So this is our trust. And, just like a will, you can create it. And if you could see each one of these little nails on here might be a different clause of my trust. And I might say that, I want to leave everything to my spouse, and then I want to leave everything to my kids, and so forth. Okay. For example, I see in our participants, I see Jan. I'm going to pick on you just for a minute. Hypothetically, let's say that you and I are married. Okay. And we have three lovely children. Our first child is Frank, and Frank is our golden child, and we have this chess piece. Okay. And then we have Dale. Hello, Dale. I just saw Dale. I was in Germany, And so we met on vacation, and she wanted to see our presentation here today. So Dale, I'm going to pick on you. You are our spendthrift, and Dale has sports car. So she's not, maybe not so responsible. Okay. And finally, our last child, we have Kim, and I have a silver dollar for Kim. She does really well, and so she's a big saver. So we have our three kids. Okay, so Jan and I are married, and during our lifetime, this is our piggy bank, and we're going to leave everything to each other, and then the balance goes to our three kids. But if we just name our kids as beneficiaries on our retirement accounts and so forth, well, we already know Dale has a little bit of a spending problem, and that's why she has sports car. Okay. And then we've got Kim. She does really well, but she's married to Adam. And Adam, what is your nickname that everyone calls you?
Are we being serious?
Yeah,
Dante.
the jerk. So this is a flask. So if Jan and I name our kids outright as beneficiaries, we already know one has a spending problem, and then the other is married to the jerk. If the money goes to them outright, and then Kim gets divorced to the jerk, well, what happens to half of that money? It gets split, right? So yeah, you can name your kids as payable on death. You can name them as transfer on death. You can name them in your will, which won't avoid probate. Your wishes are met in terms of they're beneficiaries, but the assets are not protected. And so that is what a trust is for. That is what a revocable trust is for. So how does that work? Well, in this scenario, if we look at our treasure chest again, during the lifetime of Jan and myself, our assets are in our names. Okay, the trust doesn't own them yet; they're in our names. But after we both pass, that is when our assets go to the trust for the benefit of our children. And then I have this lock and key here, who we would give to someone known as a trustee. In this situation, maybe we pick Frank as our trustee, our own child, and he manages these funds for all three children, always takes care of them for their health, education, maintenance, and support, gives them payments over time. If they're in a good place in life, then they can get the balance. There's no problem there. But if they are going through a divorce or they have spending problems, well, maybe we want to slow that down a little bit. Okay. So that's the purpose of a revocable trust. The most common scenario is that minor children, and get a chance to change screen, share the screen. Adam, can you see my screen or no? To the main screen.
I can see your screen, but I'm seeing your the presentation, not the presentation mode, the full screen. I'm seeing like a different screen, maybe.
I
Did
see.
you? So I can see your current slide and the full slide. So maybe it's just a different screen.
Yeah. Good idea. How about now?
We're good now. Perfect.
Awesome. Sorry about that. Wrong one. So revocable trust. Again, it is you can make changes. And main purpose, one of them is to avoid probate. Real estate. So a lot of people like to quit claim their real estate to their kids. Does that avoid probate? Yes, but you just created two major problems. The first one is a tax problem because now it's a gift. So then when they pass away and it goes to their kids, they do not get a step up in basis. They will have to pay tax on that. Secondly, if you quit claim a piece of real estate to your child and that child passes away, now that piece of real estate belongs to their spouse. Speaking of spouses, you quit claim a piece of real estate to your child and they get divorced. The house that you're living in now belongs subject to that divorce. So you never want to do that. Okay, a trust is the best way for real estate to pass to avoid probate. Some people like to do what's called a transfer on death, which you can. It's kind of like the situation that I talked to you with your car. The issue with that is, let's say you have three children, you name all three, you pass away. It will avoid probate. However, not only do they have to agree on the sale of the house, but so do their spouses, because now they have to sign off dower rights. So that is why for real estate, a trust is the best way to go, because you appoint one person, just like you would a will, to be in charge. The proceeds are split just like you would in a will, but the difference is you could put the house on the market the next day instead of having to go through a year in court. Okay. Taxes, yes, a revocable trust can help with taxes. It's not that much of a big deal today because taxes, the exemption is around 12 million a person, meaning that you will not pay a federal tax, unless you have 12 million or more. So that's 24 million if you're married. Minor children, very common. A 7-year-old cannot inherit, but if you have a 19-year-old child, do you want a 19-year-old inheriting $1 million? Probably not. So that is where a trust is set in place. Someone else will manage the money for them. Divorce protection, we talked about that already. So, it's like a safety net or an insurance policy, if you would. Yeah, you can name your kids as beneficiaries of your investment accounts, but why not put an extra protection in place to say, at the time of my death, if they're going through a divorce, instead of getting this money outright, it's going to go through the trust. Of course, if you're getting sued, or your children are getting sued, the trust will protect them from that. I have a case right now, and their brother and sister, and dad passed away. The brother just started going through bankruptcy. Just started. And he's going to get this inheritance, and he could have had a blank slate. And now, because he's going through the bankruptcy, he's going to lose a significant portion of that inheritance. Had his father had a trust, it would have went to the trust first. The bankruptcy would have been over, and then he would have gotten the balance. He could have had a blank slate and a little the inheritance as well. Okay. Of course, revocable trust is private because it's not going through probate. You don't file it anywhere. Okay. And when you talk about, you might be asking yourself, well, do I need a trust or not? I've named a lot of different circumstances. There is no one size fits all, but one that is a black and white is if you have a special needs child, hands down. Number one, if it's a special needs child, they shouldn't be inheriting the money because they probably can't manage it themselves. But if they're on SSI or Medicaid and they just got an inheritance from you, well, you just kick them off their benefits. And so a trust is absolutely mandatory. Okay. So that's our second planning tool. And we get into our final planning tool, which is long-term care planning. So I'll scare you just a little bit. Who needs long-term care? Virtually all of us. So 60% of Americans will need some kind of long-term care. And if you're married, that means that you have a 90% chance that one of you will need long-term care. This was just astonishing to me. So, leading cause of death, you might think it's cancer. It is not. Brain-related, Alzheimer's, dementia. And I get the question all the time, and this is a bit morbid, and I apologize. But well, Dan, how can if I have dementia, that cause death? Well, because you forget how to swallow and do the daily things. So that's why. So it affects all of us. 2/3 of bankruptcies are nursing home related. Nursing homes being the most costly, and I say 60% of us are going to need long-term care. That doesn't mean that 60% of us are going to need a nursing home. It just means some kind of long-term care. Here's the cost of it nationwide. So the average cost of a nursing home is $114,000, and per year, if my lawyer math is right, that's $9,513. I put this check on here. Imagine writing this check every month. I wrote in the memo month 1 of 37, and that is because the average stay in a nursing home is 37 months. Home health aides are, if you can go that route, it's a lot more affordable, especially if you could stay at home and you have that ability and family helping out. Assisted living isn't quite as much. It's $78,000 a year. But so now that we know it's very expensive, what would happen if worst case scenario, we went to a nursing home, how does that work? Well, you're in a spend down. Who pays for long-term care? You do. Medicare will pay for the first 100 days. And then after 100 days, you're paying out of pocket. Or if you have long-term care insurance, then long-term care insurance may kick in, but there's a waiting period typically. So that is referred to as a spend down, and it is a different state to state deal. I think you're in California, but it is different state to state. But federally, all states fall under some of the same rules. And there will be a spend down, and that's your assets and income. Okay, so what assets are spent down? Everything. If you're married in Ohio, there is a range. The maximum that you can keep is $154,100. So that means if you're married and you have $500,000 in assets and one of the spouses goes to a nursing home, they will have to spend that down to $154,000. If you're single and you're in Ohio, you have to spend it down to $2,000. So if my lawyer math is right, if you have $500,000, you're going to spend through $498,000. Okay. Once you hit these maximums, then Medicaid kicks in. And now Medicaid is paying for you instead of you paying out of your own pocket. Okay. If you're in the spend down, there are some exclusions. There are some things that you do not have to sell or spend, but there are caveats. So one of them is your home. It doesn't matter if you're single or married. But the caveat is this. So you don't have to sell your house, but what about the expenses to keep upkeep it? And finally, I look at it like this. Your home is kind of in jail. Because if you go to a nursing home, the reason it's in jail is the nursing home gets paid, or i.e. Medicaid, on the back end. They put a lien on your house, and then after you pass, instead of it going to your kids, it goes to that's the lien gets paid. Okay. And the whole point of this long-term care, I'll just let the cat out of the bag, is if you create a trust, specifically an irrevocable trust, one that you cannot change, you protect your home. You take it out of the equation so that they cannot put a lien on your house. Right? Some other exclusions are your car. If you need a nursing home, they actually cannot force you to sell your car. Obviously, personal effects, tables, chairs, pictures. They can't force you to sell these things. I get the question always, what if I have gold? Well, if you have gold and it's under your pillow and they don't know about it, then keep it that way. Okay? Keep it that way. Prepaid burial. So if you're in a spend down, you can purchase a prepaid burial for yourself and immediate family members. And I realize this may not be the most joyous Christmas present that you could give your kids. But if you're in a nursing home and you have the option of either giving your kids a $15,000 prepaid burial or giving it to the nursing home, which would you rather choose? Right? So it's give and take. Home improvements. So this is really great for married couples. Let's say that husband goes to a nursing home because he had a fall and wife's at home, but she has a hard time getting up and down the steps. She could go and put a $100,000 addition to get the laundry on the first floor, and you will not be penalized for that. Okay? You will not be penalized. So again, how do we pay? It is out of pocket. And the average cost is $365,000 for the average person. What can we do? Well, let's put it all together. I'm putting it together with the irrevocable trust, and I'll give you an example. So this is Dorothy, and true story. So I met her. I know Adam's a big Browns fan, being originally from Cleveland, and I was doing a probate case in Cleveland, and I was walking up I drive a truck because I go camping, and so I don't park my truck in the parking garage. I park it outside in the lot, and I'm walking up this hill in the Muni lot near Brown Stadium, and I see Dorothy, and she's really struggling. And so I go to help her, and she's out of breath, and she's an interpreter for the divorce court, which is what probate court is. So I walk her over there, and what would have taken me 5 minutes took us 20. I handed her off to the guards. And so a few days later, there's a big box at my office. And I'm like, what is this? Well, she tracked me down, and she made me a big box of cookies. So I called her back, and then she tried to introduce me to her niece. So unfortunately, Dorothy's health did decline, and years later, I got to meet her niece because it was her power of attorney. But here's her scenario. So let's say she's 82 years old, she's married, and her and her husband, they have a house in Rocky River. That's a suburb of Cleveland. And they have $220,000 of a house and $500,000 of liquid assets. And when I say liquid, that's just anything. If you can cash it in, it's liquid. They also have a long-term care policy paying $100 a day. So our mathematicians, that's about $3,000 a month. Okay. So she goes to a nursing home. Do her and her husband have to sell the car? No. And first, if she goes to a nursing home again, she is paying for the first 100. I'm sorry, Medicare is paying for the first 100 days, and then they're paying out of pocket. So they don't have to sell the car. Can she do prepaid burial? Yes, for her and her husband and immediate family members. Does she have to sell her car or personal effects? No. Can her husband put an addition on the house? Yes. Okay. Does she have to sell the house? No, but Medicaid's going to put it on a lien on it, and that's why you put it in a trust. So her spend down between her and her husband, she is married, so they can keep 154,000. So their spend down is 345,000. Okay. Looking at it differently, remember she has long-term care, so her exact cost is 9,700. I subtract out the 3, it helps. And a big point of long-term care planning, it's not one solution will take care of everything. It's usually a combination of a lot of things that will reduce the cost significantly. So that reduced it by a third. Okay. But what assets are spent down? Oh, I say the house is part of it because they get it on the back. So what could she have done? Hypothetically, if she has all her assets, including the house, and she subtracts out what her and her husband can keep, so that's 565,000. Hypothetically, if she put 565,000 in an irrevocable trust, and she did it 5 years ago because Ohio has a 5-year look back, and then she goes to a nursing home, well, what's her spend down now? 0. It would be 0. Now, Adam would kill me if I recommended that to a client to put all of your assets in one of these trusts, and I never would. But the no-brainer is your home. Because if you you can't just put retirement assets into an irrevocable trust. You first have to cash them in and then put them into the trust, and you're going to pay a huge tax implication on that. So it's not worth it. But your house, there is 0 tax implication. And I don't have an age on it, but for clients that are 65 and 70, it's when I post the question, and it's, do you plan on living in your house for the rest of your life? Is it paid off? Is it single story? And if the answer is yes to all of those questions, then I say you might want to put your home in this particular trust, and then you would have a separate trust for your other assets. So this way, if you did have a major spend down, your house is at least protected and you can give it to your kids. Again, one size doesn't fit all because some people might be self-insured. And if I have a client and they have $2 or $3 million and their house, I'm probably not recommending this type of planning. But if I have a client and they have $500,000 in assets and a house, then they're an exact fit for someone who you want to protect the house, because there's a good possibility that you might spend through those other retirement assets. Speaking of the other retirement, so it does require more of an analysis. Can you put other assets into one of these trusts? Yeah, but I think exploring long-term care insurance first and only putting real estate is the way to go for an irrevocable trust. Finally, so again, coming back to this, I said I would say it twice. And this is just another way of looking at it. So again, depending on where you're at in life, you may find yourself in 1, 2, or all 3 of these categories. And, we have our basic plan, and everyone needs that. Doesn't matter if you're 20 years old or 100 years old. And even if you have a trust, you still have to have someone who can make decisions for you if you're incapacitated, if you can't make them yourself. That has nothing to do with death, right? So those are the last four: our financial POA, healthcare POA, living will, and HIPAA. And if we've done everything right, then our last will, we will have it, but it's never used. And as we move along in life and we have kids, you consider getting a revocable trust to avoid probate, protect assets for young children or irresponsible children, or divorce protection, or a combination of everything. Just making sure that instead of our children or beneficiaries getting money outright, it first goes to the trust. If everything is good in their lives, it can pass to them, close the trust out. It's not needed, but it's like an insurance policy just in case. And then finally, our asset protection trust or long-term care. It's a separate trust just for the house. You can put other assets in it, but there's other things to consider first. And main purpose is to leave a legacy to our kids to shield our real estate from long-term care costs. So this is us, and we are right at 2 minutes to 1 o'clock. This is our firm. I'm glad everyone was able to join. No questions, but that's okay. And if anyone has questions, my email is on there. Feel free to email me directly. Of course, we do offer free consultations also. And depending on where you live, we can meet you in Columbus or Cleveland. Initial consultation is free. We use that to do an analysis or what have you.
Hey, Dan.
And thanks again.
Andy C's got a question. Andy, if you want to unmute yourself, you can go ahead and ask, or you can type it in the chat, whichever you prefer.
Yes. Thanks, Adam. Dante. I wanted to follow on that example on goal that that your parents, for example, just put under the bed, right? So let's say if I have a goal and put it under the bed and never tell anyone, right? So if my son inherited get that goal and he wants to sell it later on, how is he gonna, how about the tax basis on it? Like, how would he say, where he get the goal from? Isn't it like tax consequences on that?
Yeah, it's a really good question. So let's call it cash.
Right.
You put cash under your pillow. So this is, I'm actually serious when I say this, but it's also funny. So let's say you have 3 kids and you have cash or gold under your pillow. Who inherits that cash or gold? It's the first person who finds it, because there's no way to prove that it existed. There's no account number associated to it or what have you. Or cash is cash. So if you put it into the bank instead of spending it, and yeah, the government, if you get audited, they may ask where you got it from, and then you may have an issue there. And same with gold. But even with gold, and Adam, I know with stocks, you inherit the stock and you get a step up in basis, and there's no tax implication there. But with gold, it's not. What is the basis of gold? I don't know how that works.
Yeah, it would depend on when you purchased it, who you purchased through. If it's physical gold, there should be some record, or you should have some record of what it was purchased for and where from. And if this gets too deep and we want to talk offline, Andy, we can definitely do that.
Okay, sounds good. Thank you.
All right. Anybody else have any questions? If you do, raise your hand or just unmute yourself and talk away or add it to the chat. Otherwise, I'll just start the outro here and mention that the next event. Well, first, actually, one more. I want to plug something we're doing at the office before, because this is such a perfect presentation to do it on. We do this thing at our office called a My Promise Kit for all of our clients, and this is it's not only a physical safe that we create where Kim sends out a checklist of all the things to put together. We collect those things from you. We build out the kit and the fireproof safe with a bunch of hanging files. These are things like healthcare directive, powers of attorney, trust documents, investment statements, brokerage statements, insurance policies, a place to put your passports, a password organizer. The list goes on. It's basically your financial house inside a fireproof safe that you would keep at your home. And then we upload all that to what we call the My Promise Vault, which is an online encrypted site where you can have this stuff available 24/7 wherever you are in the world. Literally, we had a client in China once who lost their passport and was able to go to the embassy and download it. That's not the most orthodox way to use this kit. That's not what it was intended for, but obviously that you can literally use it for anything. You go to urgent care in Florida because you're on vacation, you have that with you 24/7. We also have ice keys that we put this on. That's a USB key that goes in your keychain. Nothing on it is personally identifiable, but again, you have it on your keychain, or if you have college age kids and they're going to school out of state, we give it to the kids as well. So if your daughter goes to the medical center, you get a phone call from the doctor saying, "Hey, saw you were next of kin at the registrar's office, but I can't tell you what's going on because we don't have a POA on file." Well, it would be on our keychain. So this is something that's really cool that we started doing during COVID because basically we went from having 25 appointments a week to having 3 appointments over 8 weeks. Happy hour just got earlier and earlier over those days. But so that's a really kind of a estate planning thing that we do at our office above and beyond the stereotypical financial planning and investment management firm. Second of all, our next events. So if you didn't get enough of Dan today, you can come and see us in person at J. Lou in Worthington on November 6th at 6 p.m. We're going to be in the upstairs ballroom. We do an event every year. It's called Health, Wealth, and Aging. Dan's going to be talking for about 20 minutes. We have Dan Brookman from Stolly Insurance, who's going to talk about long-term care for about 20 minutes. Josh Kinzel from Seniority Benefit Group is going to talk about Medicare and Medicare supplement policies for about 20 minutes. And then I'm going to get up there and rattle off, some information about estate planning as well. But so check if you're interested, that is open to the public. So again, that's November 6th at 6 p.m. at J. Lou in Worthington, Northern Columbus, in the ballroom upstairs. Just shoot us an email to RSVP. And then our next virtual event is one that's always near and dear to my heart. Every November, we theme the month Nerdvember. And on November 19th, I'm going to be talking about really, really nerdy technical analysis, trading, investment management type stuff for the nerds out there that want to talk about that kind of stuff. So those are our next two events. If you'd like a second opinion on your estate plan, if you don't have one, which by the way, 52% of people don't, so don't feel bad if you don't have one, please go to baronlawcolumbus.com, or you can just email Dan directly at dan@baronlawcolumbus.com. He can be reached at 216-573-3723. And you can find him on LinkedIn as well. That's pretty easy. If you'd like a second opinion on your estate plan, retirement income plan, investment management strategy, you head over to libertaswealth.com. There's a little button you can click on. It'll say check to see if we're a good fit. Click on that, answer the questions. Again, we'll get an email. We can set up an intro call. And then like I said earlier, I've known Dan for a long time. And as we get into the estate planning section, if you're not sure if you want a second opinion on your estate plan now, we can help you determine if you do or not. And like I said, Dan and I work very closely together. So I don't see any more questions. I don't see any more hand raised. So we're going to go ahead and end. My apologies, 5 minutes later. If you'd like to see the replay, this is going to be on our website. It's going to be on YouTube as well as all the socials. So thank you so much for joining. Dan, thank you for being a part of this presentation today. It was awesome, and we'll see you all soon.
Thanks for having me. Take care.